My Lord, I don't want to take up any time, but Mr. Harris did raise with me the question of timing. I don't know whether there's any indication that your Lordships want to give us to either whether possibly you might be able to sit late or early tomorrow, or how, or whether we think we can go into the third day.
The short answer is that we'll see where we are when we get to 4:30. I can't sit early or late tomorrow, I'm afraid. So we would have to go into Thursday. If we did have to go into Thursday, we would, again, I can't sit early. We'd have to start at 10:30, and in view of the timetable that the parties have given themselves, we would not want to be more than an hour.
I mean, one possibility is that, I don't want to take up time, would be that the replies, such as they were, would be on Thursday, and we've heard that indication. I don't know what your Lordship thinks.
But the trouble is, at the moment, if you allow people to go into the third day, they think of more things they want to say, and it ends up lasting even longer than it should do.
Well, I'll gallop along as best I can.
Well, don't gallop. Take the time that you need. I'm simply indicating that we would, in extremis, be prepared to sit into Thursday, but you shouldn't take that as an encouragement to simply expand your respective submissions to fill the space, rather like Parkinson's law. If anybody else is old enough to remember that, which you probably aren't actually.
We tried to work out a viable timetable for 2 days, so we'll do our best to stick to it.
All right.
I'd made some remarks about the UKTC, my clients, before the short adjournment, and I was just going to comment briefly on the RHA. And I'd just say, by way of introduction, this is not, as it were, a beauty contest where it would be inappropriate to reconsider the position adopted by the CAP. We say that there are fundamental differences of approach which raise issues of law. The issue of conflicts and class definition we've already touched on, and I'll come back to it. There's the question of aggregated and individual damages, the opt-out and opt-in issue, which your Lordships have obviously been thinking about in another context. And there's also the question of the two CPOs and our ground two. But just by way of outline in relation to the RHA, we say that even as amended by the CAP, the RHA is pursuing an extremely complicated set of claims for individual damages, operating at 3 levels with 4 different regression methodologies proposed to assess loss at each of those different levels. It's seeking damages on behalf of both direct and indirect purchasers based on the common activities of haulage firms, not on their position in the supply chain. And although Dr. Davis intends to use a number of simplifying assumptions, it's clear that he does intend at trial to demonstrate individuated or individual opt-in damages truck by truck, and that's clear from evidence he gave, which is quoted at paragraph 135 of the judgment at page 277. He said he was seeking individual damages for each individual truck in each subclass and then add them up. Fundamentally, what we're shooting at here is individual damages, and that's a point that's repeatedly referred to in the CAP judgment, paragraph 74, 81, 117, 173, 182, 186 and 215. And in my submission, that is an ambitious approach, and one can see just how ambitious by reference to the outcome in Royal Mail and BT, which was, in one sense, the simplest case you could possibly have of 2 very large direct purchasers and no runoff period. And your Lordships were taken to it this morning, but I think it's worth just looking at it briefly again, and that's at tab 46, which is its own little file. In my version, I've got it in bundle 9. And I know it's a painfully long judgment, but there is in fact a very short section at 2105 to 7.
(2105).
I took 2102 to 2105, my lord. And there's a passage from 475 to 478 where the tribunal summarises basically its understanding of how the cartel worked insofar as it can discern that, and whether or not the basic requirement of causation had been satisfied. And at 477 they summarise the issues that they have found and conclude at 478 that the claimants have established the requisite causation to complete their cause of action. And in my submission, that analysis is very similar to the approach that Dr. Lillico adopted in each of his reports. The question of causation was essentially one for economic reasoning in the light of the cartel decision. But the more important, and probably the most important paragraph in the judgment from our perspective is the next one, and the approach of the broad axe to this question and the regression analysis adopted by the two competing experts. And if one sees in the third sentence, to engage in a detailed mathematical exercise of this kind might appear to provide some credibility to the figure we end up with. However, we take the view that it would be an exercise in spurious accuracy to attempt to do so. Several of the imperfections in the experts' regression models don't yield a definitive solution, and we believe that no regression model could. As we made clear in the sections above on exchange rates and the GFC, the global financial crisis, the true value of the overcharge we believe somewhere between the two experts' diametrically opposed positions. In the circumstances, we have no choice but to make a judgment based both on the evidence that was presented in the experts' model and on a wider appreciation of the factual context and witness evidence. And then in the remaining paragraphs of this section, they ultimately conclude that at 484, that a broad and reasonable broad axe view on overcharge comes out at 5% for both claimants, approximately half what they're claiming. And we have no reason to adjust the profile of this overcharge between the different years of the infringement, and indeed to do so would imply a greater precision to the broad axe approach than we consider is justified, given the substantial imperfections in the data available and the complexity of the task. So, in my submission, that is a highly relevant set of findings by a tribunal that I think had seen 40 different expert reports on the very methodology that Dr. Davis is proposing. And we rely on that to some degree in response to the respondents' notices and the challenges to Dr. Lillico's methodology, because I think your lordships were offered the opportunity to look at Dr. Lillico's reports, and in particular the passages in his first and fourth reports where he expressed concerns about how viable a regression methodology would be.
As I said before the adjournment, Mr. Thompson, that's all entirely a matter for the CAT in terms of they decided that your clients satisfied the relevant criteria. They simply chose RHA rather than you.
Yes, indeed, my lord.
Speaking for myself, those seem to me to all be matters of case management for the CAT, with which this court won't interfere.
Yes, I'm only...
Somebody can identify an error of law for us, that's a different point, but I haven't seen one yet.
My lord,
The IMAX applies across both for the future, across Mr. Davis and across any competing methodology. It might make any further trial much more easy if everybody's aware the CAT will swing the axe.
yes,
It applies it to everybody, doesn't it? It enables the CAT to overcome all sorts of difficulties by saying wide margin, but we look at other evidence, indicative evidence, and find a weird media.
yes, my lord. The reason I bring it to, apart from there's obviously a degree of prejudice involved, but it's also that that the...
It's a very good reason, point made.
Indeed, my lord. But the other point is in relation to aggregate and opt-out damages, where your lordships will be very familiar with the various indications you've given in a series of judgments about the advantages of an aggregate and opt-out approach. And we do think that the RHA Davis approach is pretty much at the opposite extreme from the suggested advantages of a top-down aggregate approach, which is effectively what we proposed. So in my submission, that it goes to that point of law as well as the question of prejudice.
It goes to perhaps a different point, which is that you both have very different scopes for your claims. You're going for an opt-out aggregate damages and they're going for opt-in individualised damage. So your claim is much broader. That may or may not be a good thing. The cat has to choose between two quite different claims here. But I mean, you can understand why this might be an opt-in. The RHA is a trade association, it knows its members, it's able to manage them in a different way, or in a way which you wouldn't arise with a Merrick's type case when you've got millions, or the Petrel when you've got hundreds of thousands.
Yes.
It's a different dynamic, and the cat's just making an assessment.
Yes, I mean, our classes are fat and thin in different places, as it were. We have gone for a single opt-out across the new trucks group, and we say that that avoids the conflicts problem, and indeed that was the basis on which the definition was chosen. And we say that the RHA has, as it were, fallen into a hole by concentrating on whether they did road haulage rather than whether they were direct or indirect purchases. So that's obviously a key issue in relation to ground one. There is also an exclusions issue in that our class is wider because we effectively allow anybody who bought a new truck, whereas again the RHA is focused on road haulage firms, and so in particular rental firms are excluded from their class definition. So that's a difference, and I think your logics need to be aware of the big picture differences between the two applications in order to understand my submissions. But I won't take any more, apart from the run-off period, which I think your lordships have already mentioned, in that the RHA has a 4-year run-off period imposed by the CAT, whereas they've been advertising, I think, until very recently, until May 2019, and that I think is an issue that may cause questions about how exactly the opt-in process will work. But again, that's perhaps in the weeds, and I don't need to take up time on that. Can I now move on to the errors of law and the structure of the way we put the issue? The CAT found that both applications met the statutory criteria, which is at paragraph 2611 at page 328, but that only one, the RHA rather than UKTC, should be certified, which is at 2612, also at page 328. So there were therefore 3 critical steps in the CAT's reasoning, although in a sense they took them slightly in a different order. But the first was that only one CPO should be granted, which was section K, which is pages 300 to 302. Secondly, that the conflicts within the RHA class were not a roadblock to certification of the RHA application in its amended form, and that's section M, pages 316 to 326. These are all core bundle tab 17. And then thirdly, on those 2 assumptions, the RHA opt-in application was preferable to the UKTC opt-out application, and that's section L, and in particular paragraphs 197 and 231, pages 302 and 315. So the findings at sections K and M were critical to the judgment. If both CPOs could have been granted, the CAT itself found that there was no other basis not to grant the UKTC application, and indeed the CAT had originally indicated that that was its view at the very first CMC back in 2019, which is in the supplementary bundle tab 12, page 219.1. And secondly, if the conflicts issue inherent in the RHA application was a roadblock to its certification, then that application would either have been refused altogether or else would have to have been further amended by the CAT to eliminate the conflicts. So our basic submission is that CAT's analyses at sections K and M were both clearly wrong in law and contrary to the objectives of the regime. And it follows that on the basis of the CAT's own finding that it was desirable for a collective order to be made on behalf of both new truck purchasers and used truck purchasers. For example, at paragraph 204, 2 CPOs could and should have been made in a non-overlapping form, appointing the UKTC to represent new truck purchasers on an opt-out basis and RHA to represent used truck purchasers in its favoured opt-in basis. We say the benefits of that would have been twofold. It would have eliminated the conflicts in the RHA class, and it would have reflected and furthered the statutory objectives identified by the Supreme Court in Merricks and by the succession of subsequent Court of Appeal cases by having an opt-out aggregate assessment of the total loss by purchase of new trucks during the cartel period, the very products that were the subject matter of the cartel decision and the admissions of the cartelists, so they would have had no complaint. So our ground one is that there was an erroneous conclusion on the conflicts issue at section M of the judgment. And our ground two is that there was an erroneous conclusion on the multiple CPOs point. And in particular, the CAT failed to consider the possibility and the obvious advantages of non-overlapping CPOs for direct and indirect purchasers at section K of the judgment. And then we support those points by our grounds 3 and 4.
Right. Do you have any idea of what the total cost of 2 CPOs would be? What would be the... So that's 2 lots of costs, 2 lots of insurance premium. How great an escalation of total costs would having 2 teams going to trial involve? Because we've got the hybrid category in between, which is quite a lot of people who've got to go betwixt and between.
Well, I'll come to that point in a moment, my lord, if I may. That my basic submission is that if you were a new truck purchaser, you would be included automatically, and the overcharge would be assessed on the basis described by this court, for example, in Gutman or Le Paterel, or indeed by the Supreme Court in Lloyd and Google. And as your lordship just put to me, that might actually be quite a short process given the findings in Royal Mail and BT.
Might suggest that
depending how broad the axe was that was wielded.
RHA might not find it terribly attractive to run with just the used.
Well, I think there has to be an undercurrent here that the RHA very deliberately chose the bed that it chose to lie in, and if it's not a very comfortable bed, then that was the very reason why we didn't lie in it back in 2018. In my submission, just because we feel a bit sorry for RHA that they made a bit of a mess of it, that doesn't mean that the court shouldn't say they've made a mess of it.
What would happen if the CAT said, we've come to a pretty clear provisional view? We think that we will certify 1, but only for the new and not for the used after Royal Mail. What then?
Well, the finding of the CAT at the moment is that used is a valuable additional set of claims, and I think the latest figures that I've seen in the evidence was that there are 85,000 used trucks in the RHA class, which, even if it's not as much of a payday as for the new trucks, that's still a significant potential claim on an opt-in basis, and presumably there'd be hope that more might opt in. Of course, it may not be a good claim, but that's, again, not really something that I need to worry about, or indeed I think the court. Yes, I've been handed up paragraph 204 that the CAT's finding back in last June was that the inclusion of used trucks was a significant advantage, and so if it holds to that position, then presumably it would be inclined to make a CPO for used trucks. And again, I don't know about the position in terms of viability, or but if it isn't viable, it rather begs the question whether it was such a good idea in the first place. And so again, I don't see that that can be a decisive question. It might turn out that the used trucks claim is not viable, and I just don't know anything about that. But I mean, the short point, and I think that you're putting to me, is would it be unacceptably costly to have separate representation for direct and indirect purchases. In my submission, the answer to that is no, because these are two substantial classes. Indeed, in Royal Mail itself, it was envisaged that there might be indirect purchasers coming forward to bring claims, and indeed it was thought that that would be desirable. And so, in principle, that would seem to be a much better way forward than to botch up the regime and have a single direct and indirect claim, which was, as it were, facing in two directions. So, and even in terms of costs, it's not necessarily going to be more costly, because for the reasons I'll come to under Ground 3, the new trucks claim might actually be significantly more straightforward to hear on an aggregate top-down basis than on the basis that's currently proposed by RHA, where I think the idea is to have individual analyses for every truck bought new in the UK between 1997 and 2014, which might be quite a challenging, very much the same points that were made, I think, in paragraph 39 of Gutman, about how exactly you would go about doing that with the OEMs present to try and work out individual damages over a 20-year period, going right back to the John Major government. And just to set out a position on the, I mean, the other point that's just been handed up to me is, as I understood the discussion before the short adjournment, it was actually being proposed that in effect the used trucks action would be hived off. And as I'll come to in a moment, that is the entire used trucks action. It's not really a subclass. That is the used trucks claim. And if it's hived off under the umbrella of RHA, apart from the conflicts issue, I don't see there's any great cost saving, because you just have a rather complicated potential conflict, but otherwise very much the same thing as having two representatives. And indeed, as I understand Mr. Jowl and Mr. Pickford, that's what they want, is two representatives and two bits of funding.
If it were the case that, assuming that was the solution to the issue, was to have a subclass with separate legal and expert representation for that subclass, assuming that the expert that was used by Mr. Flynn's clients was somebody whose expert views were similar to those of Dr. Davis, then that would mean a relatively shorter time spent on the expert evidence than would be the case if the tribunal had both Dr. Davis and Mr. Lilliker, which is a point that they make in paragraph 194 of the judgment. That they are so very different methodologies, each of which is complex and would have to be analysed and considered.
Well, I think that comes to my ground too, that the only thing the CAT seems to have envisaged would be a sort of fight to the death going on to the end of the trial, with different methodologies for different overlapping claims. But to be clear, that's not what I'm proposing. I mean, the burden of ground 2 is that the CAT completely failed to consider the possibility of having non-overlapping claims. That in my submission, the obvious solution would have been to have had a direct purchaser class and an indirect purchaser class. And the Lordships will be aware, and indeed several of the advocates here will be aware, that in, for example, the MasterCard case, Mr. Harris and his team have represented consumers, and various others, luminaries of the bar, have represented merchants.
Yeah.
And the suggestion that either the merchant class should subsume the consumers or the consumers should subsume the merchants, in my submission that would be regarded as obviously unfair, but that's effectively what the RHA has chosen to do. And in my submission, a non-overlapping class for new and used, so separate classes, would be the obvious solution to the conundrum that we face ourselves in relation to ground 1, which is effectively where we go with ground 2. Given the indication before the short adjournment, I wasn't going to say anything more about the respondent's notice. Your Lordships would have seen that in our skeleton argument, although we say there's nothing in their point, we actually say there are two related errors of law that the CAT did make in relation to the case which are adverse to us, and that's at paragraphs 96 to 101. But I won't say any more about that now. If I can now go to ground one, and just to pick up something that I think arose in discussion this morning, the first thing I'd say is that the RHA application is not the Canadian model. It's not an application for aggregate damages, and so it's not a two-stage process of the kind that I think was being suggested. As I understand it, the proposal is full trial of all issues on an individuated basis, and that's a very difficult proposition. In relation to ground one generally, we agree and adopt the submissions that Mann and Daff have made, subject to 5 points that I'd like to emphasise, some of which are subtly different from the Mann-Daff position. So first of all, on eligibility and the common issues issue, and we say in summary, the legal position is that the common issues criterion for eligibility has both a positive and a negative aspect, and one sees that in the Canadian authorities, that the issue must be common to the class. That's the first requirement. And secondly, the resolution of the issue in favour of one class member must not lead to the failure of another class member's claim. And we say that's true both under the statutory criteria and reflects the equitable position of the RHA as a fiduciary on behalf of its class members. So far as the primary legislation goes, your Lordships are obviously very familiar with section 47B1 and 5 to 8. They're at tab 4 of the authorities, pages 87 to 88. I'll simply note that the whole regime is governed by the concept of those proceedings, i.e. proceedings, 47A proceedings brought collectively, and that the suitability and eligibility criteria are and must be relative to the claims in respect of which the class representative seeks certification. And we say it follows that the CAT must look carefully at the overall class as defined in the application to see if the proposed class representative can represent all class members fairly and adequately in relation to their pleaded case. And one sees that, for example, at Rule 78.2a, which I think Mr. Gell took you to this morning. And we say that's immediately a problem for the RHA given their pleaded case, because they advance a positive factual case for individual compensatory damages for used truck manufacturers, used truck purchasers, based exclusively on resale parcel. And one sees that. I think we looked briefly at the pleading this morning, but if I could ask the Lordships to turn up the RHA pleading. It's in my volume 2 of my supplementary bundle, tab 28. And Mr. Jowell helpfully took you to the primary definitions. If you turn to page 1057 through to 1059, paragraph 71 sets out the basic pleading that there's loss and damage. 72 sets out the new trucks claim. As a consequence of the infringement, the prices charged the proposed class members for purchasing or leasing relevant trucks were at all material times higher than they would otherwise have been. But then at paragraph 75 to 77, the RHA pleads a positive case on resale pass-on, and indeed on pass-on generally to its class members. But we're concerned on this appeal with the issue of resale pass-on. And in particular, the second sentence of 75, as a result of the inflationary impact of the infringement on prices of new relevant trucks, prices for pre-owned relevant trucks were also inflated above the level that they would have been absent the infringement, thereby causing the proposed class members to suffer loss in relation to such purchases or leases. So on any ordinary approach to pleadings, that is their positive case on which they have the burden of proof to demonstrate that that occurred. And there's some slightly more complicated wording at 76 and 77. I don't think we need to look at that for these purposes. But I think the court will immediately appreciate that this pleading is no part of the new proposed class members' case. So far as they're concerned, it is a mitigation defence to that case that the OEMs have repeatedly asserted that they will seek to plead and prove, and on which they will bear the legal burden of proof. And so far as the used truck purchasers go, if and to the extent that they fail to succeed on proving this element, they have no other claim and their case will fail. We say this is the clearest possible case where the class representative cannot act on both sides of the case, with one group of proposed class members either putting or being prevented from putting other class members to proof of an integral part of their claim. We say it clearly fails the principles applied by the Canadian courts, by the Supreme Court in Lloyd and Google, and in particular, it fails the passage cited by the CAT itself, the paragraph 44 of its judgment at page 242-3, that success for one member must not result in failure for another. The second problem, and this arises specifically from my client's class members, that the authorisation of the RHA would be prejudicial to new truck purchasers. The RHA's pleadings and evidence are directly prejudicial to all NPCM's new proposed class members, in that the RHA advances a case against new truck purchasers that the OEMs have themselves said that they will rely on as a defence to those claims, on which they will bear the burden of proof. As I've shown you, the pleaded case is prejudicial to the interests of all new truck purchasers, and as Mr. Jowl showed you this morning, under the RHA's expert methodology, the quantification of used truck purchaser claims is specifically relied on to reduce new truck purchasers' claims. One sees that specifically at paragraphs 181 to 194 and the table 27 that Mr. Jowl showed you. And in particular, paragraph 194, Dr. Davis states the same framework can be used to predict the gain from higher prices as a result of the cartel achieved on the sale of a pre-owned relevant truck by a proposed class member. So he's specifically saying that the way in which he quantifies a loss to used trucks members will be used to reduce the damages payable to the new truck member. And then the third issue, which I'd like to comment, is we say the conflicts can't be addressed by notice to new truck purchasers, as the CAT found at paragraphs 246 to 252, 322 to 5. With respect, we say that the CAT's approach does not face up to the difficulties of the RHA's position. First of all, the CAT significantly understates the nature of the conflict, saying that the underlying divergence of interest as regards the level of resale pass-on would have to be disclosed. We say that's not sufficient. There is an actual conflict of interest, both as to the existence and the extent of resale pass-on, where both the OEMs, the defendants, and the used truck purchasers bear the burden of proof as against the new truck purchasers. We say that new truck purchasers would have to be informed that the RHA, its proposed class representative, is positively pleading that their damages should be reduced to the extent that they resold their trucks, and that their expert proposes to calculate their damages on the basis that the resale pass-on mitigation defence succeeds. And Dr. Davis readily admitted that in his second report, paragraph 337b, that's tab 15, page 377, where he says if the used relevant truck purchaser has a higher overcharge, the new relevant truck purchaser will recover less damages. So we say it's not a neutral exercise. Their pleaded case commits them to reducing the new truck purchaser's damages. And we say no class representative for new truck purchasers alone would adopt that position or instruct its expert to assume that the resale pass-on argument should be conceded, whether or not that was in the best interests of new truck purchasers, or whether it was open to challenge on the evidence. And we say it's clear from Royal Mail and BT, where the defence of resale pass-on failed, that it's naive to imagine that a complicated factual issue of this kind will be conceded by new truck purchasers if properly advised, or that the issue could be determined objectively by an expert instructed by RHA to assume that the resale pass-on defence or the resale pass-on claim succeeded as the basis for the used truck purchaser's claims. And that's quite apart from the concerns expressed in Royal Mail and BT that without any allegation of bad faith, experts often come to the conclusion that that favours their clients. And leaving aside the statutory position, we say the fact that there's an actual conflict of interests between new and used trucks purchasers means that it cannot be dealt with by notice or informed consent as a matter of principle. Given the fiduciary relationship between a class representative and the members of his class, as summarised by Lord Justice Millett in the Mothew case, whereas issues of potential conflict can in principle be addressed by informed consent, cases of actual conflict require the fiduciary to cease to act for at least one and preferably both of its principles. And that's at the first bundle of authorities, tab 9. It may well be that the Lordships are more familiar with this case even than I am. I have seen it before. Perhaps I haven't read it that recently.
Sorry, paragraph.
It's tab 9 of the first bundle of authorities, and it's a well-known passage where Justice Millett, as he then was, summarises the position of fiduciaries. Really the entire passage from the top of page 18 to the bottom of page 19 in the report, but the passages I specifically refer your Lordships to are the A to C on the top left, where there's a description of the nature of the fiduciary obligation, and in particular the obligation of loyalty. And then at the bottom of that page, there's reference to the society's argument running into difficulty. And then it's stated a fiduciary acts for two principles with potentially conflicting interests without the informed consent of both is in breach of the obligation of undivided loyalty. He puts himself in a position where his duty to one principle may conflict with his duty to the other. And that's a point of criticism of the Tribunal's reasoning, where they said a potential conflict was not fatal if there was informed consent. But the passage we primarily rely on is at D through to H. At the bottom of that paragraph, the fiduciary must not allow the performance of his obligations to one principal to be influenced by his relationship with the other. He must serve each as faithfully and loyally as if he were his only principal. And then
Where are you reading from?
Sorry, that's at D to E, my lord.
And what page?
286. It's paragraph 19 of the report.
So between D and E.
Yes, my lord.
D and E on page 19, yeah, okay.
This was a case in which Lord Justice Miller was addressing the position of a solicitor.
That's right.
As a single person.
Yes.
Do you say that with the informed consent of two beneficiaries, two principals, it's impossible for a corporate fiduciary to construct a structure which allows both principals to be loyally served?
Well, my lord, I don't say it's absolutely impossible, but I was going to take your lordship to the bottom of the page, paragraphs G to H, where the court says, or Justice Millett says, the fiduciary must take care not to find himself in a position where there's an actual conflict of duty, that he cannot fulfil his obligations to one principal without failing in his obligations to the other. If he does, he may have no alternative but to cease to act for at least one, and preferably both. The fact that he cannot fulfil his obligations to one principal without being in breach of his obligations to the other will not absolve him from liability. I shall call this the actual conflict rule.
I think my Lord's question assumes, for the sake of argument, that a structure can be set up which obviates the risk of an actual conflict.
It depends a little bit what's being put to me.
I think what I was actually putting to you, I mean, I fully understand that a single person, and this was a case of a single solicitor, and all Lord Justice Millett's observations are couched in the sort of singular person, can't, in a sense, serve two people equally loyally if taking from one necessarily, or say, advantaging one necessarily disadvantages another. But if the main requirement is of loyal service, is it not possible for the interests of those two principals to be served by a corporate structure where you can have loyally, people who are purely and loyally serving the interests of one and people who are loyally serving the interests of another?
Well, my lord,
I mean, it's the Chinese wall question.
I was at one point in relation to ground 2 going to come to the question of what exactly either the RHA or the OEMs are proposing here as the way forward, if, as we submit, is fairly clear that there is an actual conflict on the face of the pleading, because it's not satisfactory for the pleaded case to stay as it is, but is it really being proposed that the RHA should be effectively given a second go to replead its case, or that it should cease to act for either used or new truck purchasers? And if so, on what basis, either under the rules or as a matter of principle? And for good matter, which side of the fence is Dr. Davis going to end up on? Is he now committed to the used truck position, or is he going to be allowed to change his expert report and say, no, actually he doesn't think there is any effect on used truck prices? In my submission, until I'm told what it is that's being suggested, it's difficult for me to react, but none of those situations sound to me to be happy ones, and they all derive from the basic problem in the class definition, which on the face of it has been perfectly obvious going back to 2018. So it's questionable why they should be given a second chance to sort out the mess.
Well, as you didn't, you identified where the draft order and notice are in the bundles, and I looked at those, and I understand why you say that in their current format, particularly the notice, actually illustrates the problem you say exists of the RHA not being able to serve two principals at the same time where their interests are opposed. And I understand why you say at the moment you don't have anything suggested to address it. What I'm really asking is whether it's capable of it being addressed, or whether you say this is just insoluble, can never be addressed. It's the same sort of point I think I put to Mr. Jowl. Are you saying never?
I find myself in a curious position because Mr. Jowl and Mr. Pickford, you might be think would be cheering me on and saying the obvious solution to have a separate funded representative will be for the UKTC, a compliant class representative with funding, to take over the new trucks claim with no conflicts. But what they seem to be suggesting is that the solution is for the RHA to keep going with the new trucks, even though their case is hobbled by the fact that they've pleaded a case against themselves.
But the trouble, I mean, you spoke a number of times earlier about eliminating one of the advantages you say of your solution is that it eliminates the conflict.
Yes.
But it also eliminates a whole group of people who have been said to have arguable claims for damages as a result of the cartel, i.e. used truck purchasers.
Well, I wouldn't accept that, my lord. Their application was also made in 2018 and is still standing, and indeed was granted.
Well, I know, because your predicate, which is that effectively you have new and they have old and they have used, is the predicate for that is the availability, for example, of viable funding arrangements for just used. Now, we just don't know whether that's right or wrong.
Well, I certainly don't know.
Maybe that the funders are not prepared to just fund the used claim, particularly in the light of Royal Mail, as you say.
Yeah, I mean, you eliminate what you say as the conflict. You present yourself as eliminating the conflict, but in doing so, there's, on the face of it, a group of people who have arguable claims, i.e. used truck buyers, who won't be served by collective proceedings at all, unless somebody can get funding for just that used truck cohort.
Well, their case was pleaded from the start by the RHA. I mean, that pleading, as it stands...
Yeah, but they're trying to do new and used.
I know, but
saying,
apart from crossing out the words new, there's no problem with that pleading, because, as your lordship put this morning...
It's not pleading that's the issue, Mr. Thompson. It's the issue of practicability, if you like, which includes funding.
And also the policy, as I understand it, of collective proceedings, which is to ensure that, so far as possible, if there are people who have suffered loss and damages as a result of cartelist activity, they should have their claims vindicated. So,
yes,
what happens to the purchasers of used trucks?
But
you just say, well, you know, not interested, thanks very much, goodbye.
well, I wouldn't say that, my lord. But what I would say is that clearly this is a complicated matter where decisions were taken at a very early stage about how to structure the claim. And we took one decision and the RHA took a different one. And in my submission, what would be completely unacceptable would be for your lordships to say, actually, the structure of the RHA one just doesn't work because of this conflict. But nonetheless, we're going to grant it, when the whole basis for the claim that we've brought was to avoid the very problem which we're now confronted with.
Yes, but
namely
if that problem can be addressed, and if it is soluble and can be addressed and managed in the course of the proceedings, then why shouldn't the proceedings be certified and continue with that case management? Which is why I came back to ask you, do you say that this conflict is insoluble in a single set of proceedings, or do you accept that it can be solved?
Ironically, the one way it could have been solved would be, as it now appears from the Canadian case law in particular, by means of an aggregate claim for damages with distribution to be delayed to a later stage, at which point the position of direct and indirect purchasers could be addressed. Indeed, we haven't looked at this, but that was one of the issues that Mr. Ridyard, in the minority in the Royal Mail decision, he contemplated the possibility of some part of the damages being held back, not on the issue of resale pass on, but on the issue of supply pass on, for this very possibility that otherwise there might be a misallocation of resources and the direct purchasers get more than they deserved, and the indirect purchasers got nothing. But in a sense, that's not, I wouldn't accept that's really a problem from my case. I'm well aware that the OEMs, and in particular Mr. Harris, are intending to come roaring out with some form of pass-on claim at some point. And we've always known that was a possibility, though of course it carries certain risks. And my Lord Chancellor and Lord Justice Green have expressed some scepticism about some forms of pass-on defence in a very similar context to this one, where the cartelists are actually denying overcharge altogether. But we know that there's a possibility of a pass-on defence, and in theory there's a possibility of a pass-on claim, just as in Merrick's. All sorts of people could claim that their apples were more expensive because they were carried in expensive trucks, but as far as I know, those cases haven't eventuated. But if you bring a direct purchaser action like ours, you know there might be an indirect purchaser claim or some form of contribution, or whatever the possibility is. But that doesn't mean there's anything wrong with the direct purchaser claim. But I do say that there is a problem for the RHA, because
I
they pleaded a case.
just to be clear, I wasn't, just to be clear, given your last comment, I wasn't suggesting there was something wrong with a direct purchaser claim, except for the possibility that it doesn't address the broader policy considerations, because there's a class of people who may, on that possibility, go uncompensated.
Yes.
And so if
But
the
in a
court,
sense,
if the court could see a way of managing the conflict so as to encompass all those who might be potentially, who might have been affected by the activity, isn't that more in tune with the policy objectives of the collective proceeding regime?
Indeed, my Lord, and that is really our ground too, is that if the conflict needs to be addressed, the obvious way to do it would not be to have two overlapping claims with some form of built-in conflict both between themselves and internally. The way to do it would be to have a direct purchaser class and an indirect purchaser class. And the only people putting forward their indirect purchaser class are the RHA. And they put it forward presumably on advice since 2018. They've attracted tens of thousands of people to join that class. So in my submission, it's not really for me, who never embarked on a used purchaser claim, to solve that problem. The obvious answer is that the RHA should persist with their used trucks class on a non-conflicted basis. And to be fair, that has been my submission throughout. That was my submission in front of the CAT as well. That if the RHA wanted to bring in all these other people, then we weren't competing in relation to that. Our case was always for the opt-out aggregate new trucks class. The other 2 points I was going to make was, first of all, that the CAT was wrong to find that the conflicts would persist if there were separate CPOs for new and used trucks. Mr. Giles made the point that even if there were, it would be a very small group of people where the issue was finally balanced. I was going to make a more fundamental point that it's been clear since the Supreme Court judgment in Sainsbury's that the issue of pass-on is a question of fact, on which the party asserting pass-on, whether as a sword or a shield, bears the legal burden of proof. And we say that given that situation, there's no legal conflict or inconsistency in a claimant advancing separate Section 47A claims, asserting that as a matter of fact, he overpaid both for his new trucks and for his used trucks. But he didn't in fact pass on the overpayment on the resale of his new truck, provided he doesn't argue inconsistently in respect to the same trucks. So you could be a member of the UKTC opt-out class and hypothetically the RHA used trucks class, and they would be different trucks, because the one thing that's clear is that nobody buys and sells a truck to themselves, and so they would be different issues, and it wouldn't be an issue of legal conflict.
Quite tricky, too systemically different. Maybe on an individual case you could run that. I did on this one, I didn't on that one. But if your evidence is essentially systemic, it was or it wasn't passed on, and if it was passed on, it was X%, then it's quite tricky to.
I can see that. I mean, I was
Very
thinking,
difficult tightrope to walk, isn't it?
I was thinking more in terms of, for example, if BT bought some new trucks and some nearly new trucks, it could claim an overcharge on both, but say that its old trucks that it sold 5 years later, there was no benefit in that respect. So there's no legal conflict.
It's not inevitable.
There might well be a practical question, and you might well choose not to bother if you thought that the main burden of your case was on one side or the other. But in my submission, it's wrong to suggest that there's no solution or there's no improvement by having two different classes. And then finally, and I think it's a point that was debated this morning, we would say that the CAT and the RHA in its skeleton at paragraph 59 were wrong to suggest that addressing this inherent conflict could be postponed or left to ad hoc arrangements at a later stage. We say the actual conflict has already materialised on the pleadings and has been consistently maintained by the RHA over a period of 5 years. We say it's contrary to the guidance of the Court of Appeal in McLaren as to the CAT's proactive role as gatekeeper for it to award a CPO with an inherent conflict without addressing that conflict immediately. And again,
I don't think we said that in McLaren. We were careful to not tie the CAT's hands as to the level or extent of its case management. In that case, the case fell off a cliff once they'd identified that there was a pass-on issue. They just said, that's for trial. There was nothing. There was a void. We didn't go on and say it has to be addressed in enormous detail. We were quite careful not to.
Yes,
interfere with the CAT's discretion there.
I'm taking it as it were, a broader point that insofar as the blueprint to trial, etc., needs to be addressed, I think it's a similar point to Mr. Pickford made this morning, that it's unsatisfactory to leave a conflict on the evidence and the pleadings floating along in the hope that it won't be much of a problem.
When you say
it might be addressed at a later stage.
You say, well, sorry, maybe you haven't said, but I'll say it for you. There's got to be a notice which has to go out in a form which identifies a blueprint, or at least tells people who bought used trucks what it is they can expect to represent their interests. and I think you didn't take us the notice this morning, but I suspect you will say that the notice that's in its draft form at the moment doesn't do it.
No, I mean, it doesn't do it for used trucks to say that
You basically,
there'll be a big battalions trying to argue you should have nothing. And it doesn't do it to new, saying that, by the way, the RHA and Dr. Davis are both saying your damages should be discounted to protect the interests of used truck purchasers.
but it,
And so on both sides it's defective and it's an actual conflict.
But I mean, just going back to a point, they haven't addressed it, and the CAT did address it in para 248. They accepted that the notice, reading a little bit between the lines, they accepted that the notice may not be adequate and doesn't adequately describe the conflict and how to resolve it. But they then say in the Rule 81, notice in the future will have to be approved by the tribunal once the CPO is granted. So they're contemplating that it will be done in due course, in fairly near proximity.
Yes, and we're sort of trespassing possibly even into my ground four, is that while the position is so uncertain as to whether any notice will ever actually be issued, because it's difficult to agree what it should say, given the issue on conflicts.
I don't think the tribunal's going to ask for your agreement.
Not for me, no. But I think there's obviously an issue which is being debated between the manufacturers and the RHA about what degree of notice is required to satisfy the conflicts issue effectively, and that seems to be unresolved.
But ultimately, that's the CAT will have to resolve that if the parties can't agree. And so they'll do.
unless it's, going back to my question, so certainly this side of the court, I'm struggling with some
Yes, I'm sorry.
noise, and I don't know.
Noise, I'm not sure where it's coming from.
I don't know where it is coming from. It seems to be like a loudspeaker or something, which is,
I think it's this.
I don't know what's open.
Feedback.
Anyway,
For once, it's not the building works behind us.
Usually the sound system.
Nearly always the building works, so we can always blame the diggers out there.
I don't know whether it's just an open microphone or circuit or something. But anyway,
Shall I see if we can?
if the issue, as I understand it, if the issue is just legally insoluble, then I totally understand your submission that it shouldn't be certified because there's no hope of addressing it in the notice.
Yeah,
I don't think it is a microphone problem.
Perhaps you could all just unplug, as it were, and then one by one. No, that's a joke.
Just shout.
If it's legally insoluble, such that no notice, however ingeniously constructed or worked on, will ever solve the problem, then I understand why you say there shouldn't be certification at all. If it is soluble as a matter of addressing the question and putting in place a mechanism to deal with an identified conflict, then why shouldn't the CAT certify, but then make sure that the blueprint, the roadmap, whatever you call it, is sufficiently clear as to how the conflict's going to be addressed in the course of expert evidence and representation?
yes. Well, I think I am saying that it can't be addressed for three reasons, essentially. The win for one is a loss for the other, that you're effectively precluding the new truck purchasers from putting the used truck purchasers to proof, because the class representative is positively pleading the used truck purchasers' case. That means that they're not a suitable class representative for new truck purchasers because they've conceded a point that the manufacturers will run by way of defence. And thirdly, because of the fiduciary point, they can't do it because they're acting for two sets of claimant with conflicting interests, and that precludes them acting, and they ought to step down on the basis of the Matthew dictum because there's an actual conflict of interest. So there are three problems, and in my submission they're basically all the same problem, and they're fatal. I don't know where we are in terms of taking a break, but I don't know whether this noise could be addressed at the same time.
Well, I was going to say, I'm going to just ask the Usher, if somebody could contact, could you we're going to have a close, get in touch with Robin Bolton and get somebody technical in here now as opposed to at 4:15. Be lovely. Thank you very much indeed. Right, we'll take a 5-minute break.
Supplementary bundle. Yeah.
Just too hot, and there was like, what to say, everyone was just like, once it hit, kind of, everyone was just like drinking. What I really have done, kind of have a camper. Yeah. Here's basically a summary of everything we've just told you. You know, why is this even happening? What is this up to? It's quite a good book for It's in second supplementary. Oh really? Oh, is it that? Yeah. Oh yeah, I see that. Oh, it's a bit cheeky. It does actually mean you can stand up and just go, oh. I've actually tried today to do full pants. Often I actually do have like matches. Just write it down.
That'd be made more basic.
Okay, so yeah, no, because I mean, there's so many cases where just, for example, things where someone else has done it, someone else has just raised the judgment, and I just think,
It's not like the law society, it's all points, which are some people.
this thing's supposed to tell us that who else it's pharmaceuticals, so maybe Chancellor needs a knowledgeable friend. It must be cool. Being a judge when you know most of these when you're writing a judgment needs to be
It's a great noise in the courtroom.
Yeah.
Apparently they go eyes bulging.
Yeah.
Go, 2 kids?
Yeah, in case you are.
Not looking good, is it?
And sometimes if you're cheeky about it,
Before I go on to ground two, I just make a couple of remarks about the issues we were debating. First of all, we've done some rapid calculations, and on the latest figures we have, and they may have gone up, 85,000 trucks, even at a £2,000 recovery, inclusive of interest, which is a fairly modest recovery, would still be £170 million. So we're not talking about a trivial matter, either in terms of conflicts or in terms of a potential claim. And as I'll come to in a moment, there are limitation issues if anyone other than RHA were to represent them. The second question is in terms of conflicts. So far as we're aware, there's no blueprint to manage those conflicts, and your lordships will be aware that the RHA doesn't recognise that there is any conflict. And our understanding is that the RHA is not like Price Waterhouse or Clifford Chance, and that the prospects of having an elaborate Chinese wall structure to manage two separate claims of this magnitude would be in itself quite a major challenge. In our submission, very much a second best to having two separate organisations or class representatives to organise this complicated litigation on a separate, properly separate basis. So in our submission, not only is it very late to start re-engineering the RHA application, in my submission it really wouldn't work, and the manufacturer's concerns in this respect obviously chime in with ours, that the better way is to have a separate class representative for new and used trucks. And as it happens, your lordships have two such class representatives before you.
But we don't have any evidence as to the availability of funding for a solely used trucks proceeding, used buyers.
No, but I don't think anyone could say they weren't on notice that this was our suggestion.
They wouldn't have known about the post office case, which might might have an influence upon their funding decisions.
You mean they may be less enthusiastic than they would have been before?
Sorry,
Well, yeah, possibly.
to be fair, your suggestion is actually just that it won't be a, well, I mean, you're saying that you suggested that they ought to go away and try and get funding for a used truck proceeding some time ago.
Well, this contingency has obviously been a possibility. Certainly, it was raised during the hearing in April 2021, so the RHA takes a long time to respond to things because its runoff period, I think, remained till 2019 for almost a year after the CAT judgment, and I don't know what they've done about the position in relation to used trucks, and obviously I can't.
No, but neither was your side, to be fair. If you were saying that you're the person best suited to go and run the new buyer's claim, and they should run the used buyer's claim, it might have been quite useful for your side to investigate the feasibility of leaving them to do that as well. I mean, I mean, if you want in, you know, that's part of your inquiry, isn't it?
Yes, I mean, our class definition in our application is basically unchanged in substance since May 2018. If I may go on to ground 2, we say it's ancillary to ground 1 in the sense that it only arises if it's found that the RHA can't continue to represent both new and used truck purchasers because of the conflict of interest issue. We say that if that point's established, then it's of critical importance that the CAT made a second clear error of law in failing to consider the possibility of addressing that conflict by making 2 non-overlapping CPOs, one for new truck purchasers and one for used truck purchasers. And there are numerous references in section K to overlapping CPOs. I think there are 5 references in paragraphs 191, 193 and 194. And at 195 it's said to be confusing for a person purchasing a truck to come within the class in both actions and to have to make an informed choice as to which class they should join. So it was clearly thinking of overlapping classes. And again at paragraph 234. We say this is a serious error of law in failing to take account of a highly material factor relevant to the exercise of its discretion, that there would have been no confusion or overlap if UKTC represented new truck purchasers and RHA represented used truck purchasers, even for class members who bought both. Someone who bought both would automatically be in the UKTC opt-out claim in respect of its new truck purchases, and it could decide to opt in to the RHA used trucks claim if it considered it to be in its best interests. And for the majority of PCMs, as Mr. Jowell explained this morning, who either buy only new or only used trucks, the choice would be self-evident. We say the confusion in fact arises under the RHA proceedings as ordered when the same truck is the subject of inconsistent claims by members of the RHA class who are successive owners of that truck. It's impossible for a potential class member to anticipate how those conflicting interests will be resolved or how the RHA's legal and expert advisors will manage the conflicts. And Mann and Daff correctly note that the only grounds advanced by the CAT for having a single class representative or a single class methodology are the tribunal's perception of convenience. That's paragraph 79.1 of the Mann skeleton, tab 1, page 31 of the skeletons. And we say that the judgment wrongly elevates issues convenience over, first of all, the statutory requirements of common issues and having a class representative capable of treating all class members equally. And secondly, the equitable obligations of fiduciary to avoid conflicting obligations towards its principles. And we also say that overwhelmingly the most convenient route for all concerned, including the CAT itself and the OEMs, who've actually put this forward, will be to certify 2 CPOs for new and used trucks respectively, to certify UKTC to represent new truck purchases and RHA to represent used truck purchases. As I say, the OEMs unaccountably don't seem to be enthusiastic for this solution, which would address their concerns. We say that the alleged inconvenience of different expert methodologies do not in reality apply if non-overlapping CPOs were made. Dr. Lillico would be assessing the aggregate level of overcharge to new truck purchasers on a top-down basis using industry-wide data, as described by the Court of Appeal and endorsed in Gutman, whereas Dr. Davis would be assessing the extent to which individual used truck purchasers overpaid using his proposed bottom-up regression analysis on an individual basis, as described in paragraphs 181 to 194 of his first report at tab 10, page 170 to 173.1. So the two experts would not in fact be assessing the same issues using different methodologies. And on the issue of resale pass-on, whether advanced by the RHA as the basis for their claims or by the OEMs by way of mitigation defence, each expert would be able to represent the separate and opposing interests of their respective client group. And the CAT would then be able to determine both of the key issues on the basis of the totality of the evidence presented by the parties on both issues to ensure there was no inconsistency of outcome. And the court will be aware that the CAT has taken extensive measures in the form of an umbrella proceedings order to try to ensure that there are no future inconsistencies of the kind that arose in the MasterCard litigation. So in summary, while the manufacturers correctly object to Section M of the judgment and demand separate representation of new and used trucks, but their solution to this problem, that the RHA should represent only new truck purchasers engaged in haulage operations, instead of allowing the interests of new truck purchasers generally to be represented by the UKTC. And I think, reading between the lines, that is the RHA's preferred solution as well, the paragraph 5 of their skeleton argument. Our submission is that this would be the worst possible outcome from the perspective of the statutory objective. In practice, it would be likely to deprive used trucks purchasers of their only effective means of recovering their losses, contrary to the statutory objective and the CAT's own reasoning. The RHA is the only applicant for a collective order on behalf of used truck purchasers. Neither the OEMs nor the RHA explains who, if anyone, would represent the interests of used truck purchasers in those circumstances, and any new collective claim on behalf of used truck purchasers has been time-barred since 2018. Secondly, this solution wouldn't satisfactorily address the conflicts issue, in that the RHA has already committed to a positive case on resale parcel, contrary to the interests of new truck purchasers, both in its pleadings and in the economic reports of Dr. Davis. It would also raise serious procedural difficulties, which I think I mentioned briefly before, requiring the permission of the CAT for the RHA, first of all, to cease to act as class representative for used truck purchasers on notice and the potentially significant costs implications, and I don't think we need to go to it, but that's governed by Rule 87 of the CAT rules at page 76 of tab 3 of the authorities. And if it were to avoid the conflict issue, the RHA would have to amend its pleadings and possibly its evidence to withdraw its prejudicial pleaded case on resale parcel, and that would arise under Rule 32, applied by virtue of Rule 74 of the CAT rules. We say both such applications would be very likely to be opposed not only by used truck purchasers signed up by the RHA as their proposed class representative since 2018, but also by the OEMs, who naturally rely on the existing pleadings and expert evidence that the RHA has served over a 5-year period.
So, just for me, can you give me the either the reference or the worst example of the areas in the pleadings or in Dr. Davis's reports that you say would cause the most embarrassment, if you like, for the RHA?
I think it's paragraph 194 of Dr. Davis's first report, where he makes it clear that the calculation of the used truck damages would act as a discount to the damages of new truck purchases, and the table 27 that Mr. Jowl took the court to this morning. I think those are probably as clear a place as anywhere. And then the pleaded case, it's paragraphs 75 to 77, where the RHA positively pleads that the resale pass-on case succeeds. And so, unless those were changed or deleted, it wouldn't really address the conflicts point, in that the RHA would positively be advancing a case which the OEMs are very likely to advance by way of defence against new truck purchases. So, in my submission, that would be highly problematic. We also say that it would be contrary to principle for the RHA to be allowed to achieve by amendment a result that wouldn't have been available to it at the CPO hearing by altering its application in a fundamental way that was inconsistent with the basis on which it was granted. And I think it's already been put to me that at paragraph 2204 of the judgment, the tribunal said that the inclusion of used trucks is a significant advantage of the RHA application, as it will enable a large number of potentially affected SMEs to pursue their claims. And that's at pages 304 to 5. So the effect would be that it had been granted the CPAO on the basis that it disowned once it was pointed out that it gave rise to an unacceptable conflict. So our submission is that once the conflict inherent in the RHA's proposed class definition is recognised, the following consequences necessarily follow. First, one of the principal plus factors, if I can use the wording of Lord Briggs in Merrick's, for the RHA's application over UKTC's application is in fact not merely a strong minus factor, it is in reality a factor that precludes the RHA from acting for new truck purchases, with the consequence that the UKTC's application to represent new truck purchases should have been allowed. And secondly, if the RHA application is now to be granted, then it should be limited in scope to indirect purchases, and in particular purchases of used trucks, which is the category of claimants whose positive case the RHA has advanced in its pleadings since 2018. Given the composition of the court, I embark on grounds 3 and 4 with some nervousness, because your lordships have written many of the judgments that I would refer to, so I think I can probably take this issue relatively shortly. The first judgment, which with respect your lordships didn't write, is clearly the judgment of the Supreme Court in Merrick's, and in particular the well-known passage at paragraph 57 of the judgment of Lord Briggs. And I don't know whether your lordships need to turn it up, but it's a well-known passage, and it's at the 5th bundle of authorities, tab 26, page 1075. And I was going to refer to the 3 advantages or the disadvantages that are avoided by an opt-out claim for aggregate damages. First of all, a multitude of individually assessed claims under the ordinary civil procedure. Secondly, that determining such claims is burdensome for the court. And thirdly, that it's usually disproportionate for the parties. And that was the reason why I took your lordships briefly to the implications of Dr. Davis's methodology, because in my submission it falls foul of all of those issues. Then secondly, the the Patterell case, paragraph 71, referring to paragraphs 25 to 27 of the Lloyd and Google case, refers to the important advantage of opt-out proceedings in overcoming low participation rates associated with opt-in proceedings. We say that remains a material factor for a class of claimants that comprises large numbers of small operators in respect of a cartel that began in 1997 and ended in 2011.
Hasn't stopped the RHA from amassing a class of 16,000, has it?
Well, no, I accept that, but
That's not the sort of point we had in mind, and the point in the Patterell was that it wasn't really feasible or viable because the amount in issue.
A few £100.
It was £200, and then in Gutman it was, I think the average was said to be £55 or something.
yes, yes.
So nobody in their right mind was going to
I'll
commence
no,
proceedings.
I understand. No two cases are the same. I understand that. And obviously, this is a business-to-business claim rather than a consumer claim. And in my submission, as it were, none the worse for that, because Your Lordship will recall that one of the objectives was not only consumers but also small businesses. And there's a very long tail. I think I've shown Your Lordships that over half the fleets in the UK are single trucks, and I think 90% are less than 10.
Well, they probably could have certified this on an opt-out basis, given the numbers and relative modesty of claims, but they chose not to, because the RHA just happened to exist as a convenient administrative vehicle for most of the claims on an opt-in. I mean, they could have done it either way, I suppose.
Yes, I if I may, I mean, I appreciate that Your Lordship are all over this issue, and I don't want to waste time, particularly given the fact that we're running a bit behind the clock. But if I could just make the points, we do rely on the passage from Gutman at paragraph 39, which again the court will be very familiar with, the link between the statutory objective and aggregate damages for opt-out proceedings, the unwieldy nature of damages assessments for large classes, and the serious case management difficulties for opt-in individuated claims. And there's a passage of Le Patterell, paragraph 107, where it's stated that opt-out and aggregate damages significantly simplify the quantification, award and distribution steps, and that's at Authorities 7, tab 39, page 1745, and actually says that the fact that opt-out claimants are automatically included in the claim can be an advantage, because how are they supposed to appraise whether or not they've got a good case? And we would say that this was a stark example of that, without going back over the conflicts issue again. And then at paragraph 68 of Le Patterell, it was said that although there was no statutory presumption in favour of either opt-in or opt-out, that didn't mean that the CAT shouldn't take into account considerations which will typically attract greater or lesser weight in the scales, and the suggestion that the guidance might need to be changed. And that's at tab 39, page 1732. So we say, applying the above principles and guidance, the advantages of an opt-out claim for aggregate damages in this case, as against opt-in proceedings for individual damages calculated on a traditional compensatory basis, are at least as valid in the present case as in others. The UKTC has deliberately sought to simplify the claim to the maximum degree by limiting its case to an opt-out claim for direct purchases calculated on an aggregate basis, based on industry-wide data. In principle, the calculation it envisages is extremely straightforward and would involve broadly the following steps: under the supervision of the CAT, but with no involvement by the OEMs once the aggregate award had been made. We say at trial there would be essentially 4 issues: to identify the overcharge percentage, either overall or by period or category of claimant, if the data permits, unlike in Royal Mail; to identify the prices paid by the class as a whole, so assessing the likely level of transaction prices and discounts and deducting a limited category of excluded categories, for example, dead or insolvent companies and opt-out claimants. Thirdly, deducting any discounts for the purposes of resale or supply pass-on that may be proved, which might of course be zero as in Royal Mail, and then to add interest at the approved rate. And then at the distribution phase, Dr. Lillico has proposed a very straightforward approach at section 7 of his first report, which is at tab 9, pages 102 to 3, which is simply to allocate damages by reference to the annual expenditure by individual claimants. And then, of course, there would be the allocation of costs and the funder's fee and payment of any residual balance to charity. And those last three stages would be conducted under the direction of the CAT, and the manufacturers are effectively out of consideration, so it would be a much more straightforward exercise. By contrast, the RHA has deliberately complicated its claim by seeking damages on different bases for different incomplete and conflicting classes on an individual compensatory basis to be determined at trial. And we've seen the approach that Dr. Davis intends to adopt. And our submission is that the trial stage, with the manufacturers fully involved, is likely to prove extremely complex and burdensome for the tribunal, with tens of thousands of calculations in respect of hundreds of thousands of trucks, based on various elaborate regression analyses over an 18-year period, applying a methodology that was found to be unworkable, even in relation to a much less ambitious exercise in Royal Mail. And then insofar as funding is relevant, which was regarded as relevant in Le Paterel at paragraphs 75 to 80, pages 1735 to 7 at tab 39, unlike the UKTC opt-out claim, the funder's fee would be taken in priority to any damages obtained by individual claimants, raising the possibility that individual claimants could find they received only a substantially discounted proportion of their reward, as well as having it discounted in relation to used trucks. And we say that the CAT made a number of errors in applying the key features of the collective proceedings regime, as explained by the Supreme Court in Merricks, both in the judgment of Lord Briggs and also by Lords Sales and Leggett at paragraphs 92 to 97 of their judgment, and again by Lord Leggett in Lloyd and Google at paragraphs 25 to 32. We say, unfortunately, the judgment of the CAT at paragraphs 217 to 223 regarding opt-out and opt-in, and paragraph 215 in relation to aggregate damages, fell into error on both issues. And we say the effect of those errors is compounded by the fact that those were the two issues, along with the issue of class definition and conflicts that I've already addressed, which were regarded by the CAT as the two key points of differentiation between the UKTC's and RHA's application. Contrary to the CAT's approach, the Supreme Court and the Court of Appeal have consistently identified substantial advantages of these distinctive aspects of the statutory regime in four respects. First of all, the statutory objective. Secondly, the interests of the parties. Thirdly, judicial efficiency. And fourthly, proportionality in managing class actions involving very large-scale damages claims. The CAT correctly recognised that opt-in against opt-out was a fundamental difference between the UKTC and the RHA, paragraph 217, and that there was no presumption under the legislative scheme in favour of opt-in or opt-out at 223. However, our submission is that the remainder of the CAT's analysis from 218 to 223, pages 310 to 312 at tab 17, ignored the guidance of the Supreme Court and the Court of Appeal on the advantages of opt-out proceedings for an aggregate award, effectively reinstating an unlawful presumption in favour of opt-in. The discussion considered only purported advantages of opt-in proceedings and purported disadvantages of opt-out, and took no account of any of the confirmed advantages of opt-out proceedings specified by the Supreme Court and the Court of Appeal. Paragraph 197, it stated that the relevant factors didn't all point in the same way, but it didn't in practice consider any of the points identified by the Supreme Court or the Court of Appeal, the considerations which will typically attract weight in the scales in favour of opt-out proceedings. Paragraph 218, it stated it was a disadvantage of opt-out, that it placed a particular burden and risk of oppression for defendants. Not a factor that I think has been given much weight in the appeal courts. It also said that, at paragraph 223, that it was a major advantage of opt-in, that there was access to a very significant source of data, which I'll come to in a moment. And then at paragraphs 219 to 223, there's an extended discussion of whether opt-in proceedings are practicable. And we would say that it was contrary to the approach of Lord Briggs in Merricks to treat any single factor of this kind as decisive. But our understanding is that the CAT's approach here is that the issue of practicability was effectively dispositive of the whole question. And I'll take that point quickly because I'm aware that Mr. Jowl, on behalf of the claimants in the recent FX appeals, submitted that it wasn't sufficient to say that opt-in cases were practical, that only opt-in cases should be certified. So I'm well aware that that issue has been carefully considered by the court, so I won't say any more about it here. And we would say that the analysis of aggregated and individuated damages was similarly superficial. In fact, it's in some ways worse, because in a single paragraph, 215, the CAT makes some comments about the pros and cons of an aggregate award, but then says that it's all determined by the relative merits of the expert methodologies of Dr. Davis and Dr. Lee, and then says again that that's all decided by the issue of access to data. With respect, we would say the CAT was wrong on both those issues. But comparison of expert methodologies does not provide a basis for the CAT to prefer individual damages as against aggregate damages. We would say whether the CAT prefers one expert methodology to another, to the extent that it's relevant at all at the CPO stage, is a completely different and irrelevant issue from the relative merits of aggregate damages or an opt-out claim. So far as access to data goes, it was said by the CAT more than once that it was a key benefit both of Dr. Davis's expert methodology and the opt-in approach that there was better access to data. That's at paragraphs 216 and 223. This factor is likely to be common to all opt-in out, opt-out debates, but it's not been mentioned in any of the appeal cases as a relevant factor. On the contrary, as the court will be well aware, the tribunal, again presided over by Mr. Justice Roth, was overruled on the specific issue of data availability to experts in an opt-out case in the Merricks case. And in McLaren, the tribunal recognised that this was an intrinsic aspect of opt-out claims and specifically rejected it as a relevant issue or point of distinction. I don't think we've looked at McLaren, so if we could look at tab 36, authorities bundle 6. It's the last, in my file, it's the last one in authorities bundle 6. And some, at least your lordships, are aware of the case from the appeal. This is the tribunal ruling and the discussion of opt-out and opt-in in that case. And I refer your lordships in particular to page 1503 in the bundle. paragraphs 168 to 170, and it was said that the key benefit that the respondents rely on as achievable through opt-in proceedings relates to disclosure, and this was rejected by the tribunal as relevant. And then they went on to say that in an opt-out case, the tribunal had power in any event to order disclosure by any represented person, and that it had a broad discretion in this respect. And so far as I'm aware, this point wasn't challenged on appeal, although, as we've discussed, the Court of Appeal gave guidance on case management powers of the tribunal, including in relation to the management of disclosure and evidence in an opt-out case. And that's at tab 44 in the following, in bundle 8. And it may be relevant as a matter of fact that the UKTC has in fact made provision for sampling disclosure in its litigation plan in accordance with this guidance, as we summarise at paragraph 80 of our skeleton. So we say that CAT basically made two cardinal errors, as we would say. It failed to take account of any of the advantages identified by the Supreme Court and the Court of Appeal in relation to aggregate and opt-out proceedings, despite the obvious differences between the parties, and in particular the ambitious approach to individuated damages taken by the RHA and its expert, and that the main factors that it regarded as relevant, and in particular the issue of data, was actually contrary to the approach that admittedly a partially differently constituted tribunal took in McLaren, where we would submit that that was the correct approach. And finally, we would say that this is another area where Royal Mail is relevant, in that even in that case, it was actually agreed between the experts that the samples available from even purchasers as large as Royal Mail and BT were unlikely to be as useful as aggregate data across the industry. And in my submission, that's again highly material to whether or not it was a properly a proper factor, or indeed a significant factor, that the opt-in class, which would inevitably be somewhat haphazard in its composition, and if there are in fact thousands of claimants for either new or used trucks, it appears to be very difficult to imagine how any sampling could be more representative as against an industry-wide approach, where of course the aggregate approach of the UKTC reflects the guidance of the Court of Appeal on this issue in recent cases such as Gutman and Le Paterel. And while I fully accept that if the tribunal directs itself properly on the law, it will have a discretion, but where it systematically ignores all the plus factors in favour of opt-out and aggregate, or rolls them up into different issues to which they're either irrelevant or questionable, then in my submission this court can and should intervene in this case, as for example it did admittedly on a matter of case management in McLaren, or as the Supreme Court did in Merrick's, where it identified a number of failures which were significantly wider than the grounds that in fact been advanced before it. In my submission here, the tribunal's analysis of opt-out, opt-in falls well below the satisfactory standard and fails to give proper weight or indeed proper account of considerations which have been systematically set out on a number of occasions by the Supreme Court and the Court of Appeal. That just leaves my ground 4, unless there's anything more I can answer in relation to grounds 1 to 3. It's fair to say that ground 4, the stay issue, has taken a good deal of adverse fire and essentially a procedural objection that it's either too soon or too late. Neither should have made it in the CAT, or that given that we currently have a stay, it's not really relevant. Well, we say that that's not relevant to the substance of the point that we are making, arising out of the statutory objective. We say that the stay that is currently in place should remain in place, at least pending the outcome of this appeal, and we would say also the Supreme Court appeal on funding, and until the issue about opt-in, if it proves to be viable, is resolved. And the underlying point is a short one, that would be directly contrary to the statutory objective for the RHA application to fail to materialise, but for the UKTC opt-out application on behalf of a substantial class of direct purchasers from a major cartel, which was found by the CAT itself to warrant certification after a very lengthy certification process, to have been dismissed after expiry of the relevant limitation period, so that no collective proceedings at all could proceed. That would obviously be the manufacturer's dream result, but it would be a catastrophe for the regime, and this case has been hanging around for long enough, and if that were the final end, in my submission, that would be a disaster from the perspective of the statutory objective.
I suppose if you're right on everything, we can simply make such orders we think appropriate to ensure that your case survives. If you're wrong, we don't need to.
I think there is a little bit more to that, because I mean, I think your lordships are not going to second guess the CAT as to the merits of our application. So ours is a claim which I think the CAT has said in terms would have been granted if the RHA's one hadn't been. And so the point is that if the RHA claim fails,
so your
for
point
any
would be
reason,
that if and just take a hypothesis, if and insofar as we did something which remitted matters back to the CAT, which left open the possibility that the CAT might then set aside the RHA claim, you need to be alive at least to come into as a substitute.
well, I think there are two possibilities that are really substantive.
If you win here, we would ensure you remain alive.
Yes.
If you don't win here and we remitted in a way which could theoretically leave an open possibility, but you could come back in some way, you would need to be alive for that.
I think there are two issues. One is, your lordships are probably aware from distant rumblings that there is a Supreme Court case
We are very
on the funding of this case, which is pending, and none of us know what's going to happen to that or what the fallout will be from it. But were the fallout that our funding survived and the RHAs didn't, then that would be one contingency. The other is, your lordships are aware that the opt-in...
Just help me with that. If PACCAR went against the funders, what impact would that have on this case?
Well,
I mean, there may be all sorts of things that might happen in the light of that, but let's assume that that judgment remains. What would be the impact?
well, one possibility, I'll put it no higher than that.
Would you be in breach of that?
Well, that's the question, and there'll be other people for other parties who'll be interested in this question. If in principle funders are caught by the DBA regime, there's still a question about whether opt-out funding agreements are DBAs. given the contingent nature of the funder's recoveries, if I put it very crudely.
Okay.
Because our position is that we recover out of undistributed damages, so there's a question about whether that is a DBA under the substance. So that's a possibility.
That's rather affected by what we said in the Petterell about
Well,
distribution. Not
indeed, my lord, but you can see that
wheels
there may,
within wheels.
you can see there may be some twists and turns on
Yes.
funding. The other is, and we've already touched on this, the opt-in process, if I can put it like that, has not run smoothly to date. And there appears to be a bit of an impasse as to what form of notice is required. And we don't know where that's going either. And
Well, we've
Your
seen
Lordship
the
will be
notice,
aware
we've seen
from-
what the cat said about it.
your lordships will be aware from FX that there are circumstances in which opt-in cases don't prove to be successful. And while I certainly understand that Mr. Flynn will say this isn't such a case because he's got thousands of people signed up, it was signed up under a different, and we would say somewhat misleading regime, but we'll park that on one side. But there's still the question about what's actually going to happen. And all we're saying, and it's a fairly modest submission, is that were the final result that the RHA application fell over, either on funding grounds or in the opt-in notification process, it would be completely contrary to the statutory objective and basically a complete disgrace if the cartelists got off scot-free by this sort of series of contingencies. I'm not putting my ground for any higher than that, really, my lord.
You want to survive to meet eventualities.
Yes, not indefinitely.
Whatever
We're
they
not,
might be.
we're not saying that if Dr. Davis fails at trial, that
No.
we should suddenly pop up again. It's that if the
For some
case
structural reason.
it turns out to be not viable, we shouldn't be dead. So that there's nothing, given that we've passed all the tests. I'm not putting it any higher than that. So I think you probably don't want to hear from me on the respondents' notices now, and I see the time. So can I just see if anyone wants me to say anything else? Otherwise, unless I can assist your lordships, I'll sit down.
Thank you very much, Mr.
My Lords, on behalf of the various Iveco entities which are respondents to the UKTC's appeal, I'm going to focus in my oral submissions, as we did in our skeleton, on UKTC's grounds 3 and 4. And I will need more than 25 minutes, but if I could make a start now
Yeah.
and make relatively good progress, I hope.
Yeah.
Now, my Lords, just to remind your Lordships of the procedural background, because it is different in relation to ground 3 and ground 4. In relation to ground 3, this is a rolled up hearing because UKTC sought permission to appeal in relation to this, saying in particular that the CAT had misapplied the Supreme Court's judgment in Merricks, and the CAT refused permission, saying that that point was misconceived. And we respectfully agree with that characterisation, as I'll come on to develop. But that's paragraph 34 of the CAT's permission to appeal ruling. Ground 4, however, is in a different category, because although UKTC say now that the tribunal erred in law, they say, insofar as it dismissed rather than stayed the action, that argument is entirely new and is brought for the very first time on this appeal. So it wasn't raised at any stage during the main hearing before the CAT, and nor was it raised as part of the consequential submissions. So the CAT didn't deal with that in its permission ruling. Now, if I can turn to ground 3 and just make a preliminary point before I respond in detail to what we've heard this afternoon from Mr. Thompson. My Lords, a number of the points made by UKTC under ground 3 effectively amount to a contention that the CAT erred in not preferring UKTC's application because, they say, there's some inherent advantage in favour of opt-out or aggregate damages claims, or some presumption in their favour, or, as they put it in writing, the statutory purpose of the collective proceedings regime is only really achieved through opt-out and aggregate damages claims. And my Lords, as a starting point, we would respectfully submit that none of that is borne out by the legislation.
But it's not borne out by the legislation, it's not borne out by decisions of this court.
Well, exactly, my lord. So just taking it in stages, starting with the legislation, the statute clearly recognises that opt-out and opt-in actions both provide access to justice. There's nothing in the statute which creates a presumption in favour of opt-out. As your lordships or as the court held in Le Passerelle, the legislative starting point is neutrality. There's no predisposition one way or another. And, my lord, so far as aggregate damages are concerned,
And what we did say was that various factors might acquire greater or lesser weight as the CAT works through them over time. I mean, you didn't want to say that they were always neutral.
exactly, my lord, it's the submission in a nutshell is that this is a classic multifactorial assessment by the CAT, and I'll take a bit more time responding to Mr. Thompson than he did developing these submissions orally. But it's actually the long and the short of it is that insofar as the CAT preferred the RHA's action over UKTC, that was an absolutely classic example of a multifactorial assessment. And there's no error of law, and really he's struggled to articulate any error of law today or in writing. In fact, the only point that could conceivably be framed as an error of law was if he was right about the failure to follow the case law, which we say the CAT was right to describe as a misconceived argument. But all of the other points are actually not even on their face errors of law. They're simply attempts to rehash arguments they lost on below. So that really is the headline submission and response to ground 3. And we respectfully submit, in fact, this is a rolled up hearing. It's so hopeless that permission should not even be granted. So there's no presumption in the statute for opt-out or a presumption in favour of aggregate damages. The legislation is neutral. And the CAT has a very broad discretion. And I won't take you to the Passerelle, I know your lordships are familiar, but we do rely upon what my Lord Justice Green said at paragraphs 55 to 57. And importantly, your lordships had in mind, or the court had in mind in the Passerelle, what the Supreme Court had said in Merricks. So paragraphs 38 to 39 of the Passerelle, my Lord Justice Green quoted from the Supreme Court in Merricks, where Lord Briggs says that the legislation gives the CAT a very broad discretion as the specialist tribunal with exclusive jurisdiction over questions of certification. Now, they do accept UKTC that they need to show an error of law, but as I say, none of the points that we've had really amount or come close to being an error of law. But can I, before I respond in relation to each of the points in turn, can I just show you two parts in particular of the multifactorial assessment which the CAT conducted? Because in my submission, they show beyond doubt that the CAT's decision was based very much on its assessment of the evidence adduced before it. And the parts of the judgment I want to just show you or remind you of are the parts concerning, one, the practicability of the RHA opt-in, and two, the relative merits or the weighing up of the respective methodologies, because it's quite clear that the CAT carefully weighed both the factual and the expert evidence. So if we could start with practicability, just to remind your lordships, it's paragraphs 217 to 223. Which is page 309 of the core bundle. And what the CAT does in this section is it refers to and relies upon the evidence or accepts the evidence of Mr. Burnett. So one sees 217, this is perhaps the most fundamental difference between the two applications. And then at 219, we consider that it's practicable for the proceedings to be brought as opt-in. That's obviously the view of the RHA, and then a reference to Mr. Burnett. And then one sees in 220 a reference to the fact that 15,000 have signed up and 1,800 have registered. And if one goes back, actually, in the judgment to paragraph 161, you see that the CAT refers there to what Mr. Burnett says about over 10,000 of the claimants which have signed up are firms operating 10 or fewer trucks. And he also gave some evidence in his fourth witness statement, which is in the bundles but not referred to, whereby he made clear that the RHA accounted for 270,000 odd of about 680,000 potentially eligible new trucks. About 40% of the eligible trucks were accounted for by the RHA, and one sees in 220 that this, not only is this the trade association acting on behalf of its members, but it's also reached out to non-members, and the take-up has been significant by non-members too. And then at the end of 220, we do not accept the submission of UKTC that this is a case where there would be a significant risk that small or single vehicle operators would not have the motivation or financial incentive to opt in. At 221, you can see the CAT clearly has in mind what Lord Briggs said in Merricks, but says that the characterisation there clearly applied to the gargantuan class of individual consumers in Merricks. It's likely to be a significant consideration for other proceedings combining claims by consumers and or where the recovery by each individual is very small. But the potential class and likely amounts involved here are very different. We consider that even small, very small firms or individual traders are likely to become aware of the proceedings, and that if they're interested in recovery, they'll take the initiative to join in. In short, we do not think that there will be significant practical problems in converting potential claimants into litigants. And, my lords, in terms of recovery, can I just show you 164, where the CAT refers to the RHA's estimate being the average damages per truck are £10,000 plus interest, and the UKTC's own estimate was £21,000 per truck. Now, what that means, my lords, is that this case is very different to all the other cases which Mr. Thompson now seeks to rely upon. So in Merricks, 46 million consumers, there was never an issue about that being brought on an opt-in basis, and the likely recovery there was said to be about £300 per head. And one sees that, for example, in paragraph 17 of the Supreme Court's judgment. In Le Patorel, I think there were 2.3 million customers, or class members, and it's recorded in the judgment that the average recovery per head would be about £148 to £333. In Gutman, it was £5 per journey, and again, a class with millions of class members. And in FX, as you know, the majority and the minority judgments accepted the evidence of the class representatives that an opt-in wouldn't get off the ground, or as my Lord Justice Green referred to, would wither on the vine. And so none of this is being challenged, these findings that the CAT has made in relation to the practicability or convertibility of the RHA's opt-in. And what that means is UKTC have to persuade your lordships that notwithstanding that RHA is a practicable opt-in, nevertheless the CAT erred in preferring that over UKTC's opt-out. So that's practicability. It's very different to other cases. And the second point, a significant part of the multifactorial assessment, was the way in which the CAT assessed the relative merits of the expert evidence. And your lordships will be familiar with section H, which is paragraphs 117 to 157, where the CAT goes through the methodology of Dr. Lillico and Dr. Davis in turn. And I won't take you through all of that section, but for example, at 139, they say they were impressed by Dr. Davis and his methodology clearly satisfies the test. Paragraph 148, they refer to a general concern about Dr. Lillico and his methodology depending on certain assumptions and the extent of data required. And although he said he could construct a model on limited data, the CAT said that's unlikely to be reliable. 157, they say we have some concerns about the primary method advanced by Dr. Lillico and the extent to which it rests on assumptions or alternatively would involve very intensive data demands. And then 215, if I can show you 215, this is important because the CAT here, and this paragraph is in the section when they are weighing up the two actions. 215, the CAT specifically says aggregate damages offer the benefit of a single final quantification, and in some cases involve a simpler and more efficient procedure. So the CAT was expressly recognising that at least in some contexts there may be some benefits to aggregate damages. But then they say, A, the quantification process for an aggregate reward is more challenging. But moreover, and you'll see they go on to say, we consider that the relative benefits of aggregate compared to individual damages are closely tied to the relative strengths of the alternative expert methodologies. And then in 216, halfway down, they go on to say that they feel more confidence in the robustness of the method proposed by Dr. Davis. In part, that's because the use of regression analysis is well tested and widely acknowledged. But more significantly, the opt-in proceedings will give Dr. Davis access to a significant volume of data. And then if I can just show you the Commission to Appeal ruling, because a large part of what's said by UKTC is that the CAT has failed to turn its mind to the potential benefits of aggregate damages, and that, they even describe that as an error of law. But one sees in the Permission to Appeal ruling, which is the next tab, at page 344 of the bundle, they start paragraph 34 by saying this is misconceived. So this is a reference you'll see from the heading to UKTC's argument about the Supreme Court case law and the fundamental advantages of aggregated damages. They say that's misconceived. And then I'll come back to this, paragraph 57 of Merrick's, but for present purposes, just halfway down, they say we recognised that aggregate damages have some benefits, but noted that such damages depended on a satisfactory expert methodology. And then they say in paragraph 35, again halfway through, they say they had significant concerns regarding the primary approach of the UKTC's expert to the calculation of aggregate damages. And then the tribunal considered that Dr. Davis's approach was more robust. So, my lords, what that shows in my submission is that the CAT did acknowledge that potentially aggregate damages in other contexts might have some benefits, at least in the abstract, but on the facts of this particular case, having had voluminous written evidence from the experts, having heard oral evidence from them, after a 5-day hearing, it decided that all of that was outweighed. The potential benefits of aggregate damages was outweighed by the fact that the RHA's expert had a superior methodology, and we say that is quintessentially a discretionary judgment by the specialist tribunal with which this court should not interfere. And so, my lords, that really is just to set the scene, as it were. And now, perhaps, if I turn to the detailed points which are made by UKTC, and we have tried to boil them down into roughly 5 points. The first being that the tribunal failed to follow recent appellate case law. Now, as to that, if we start with Merrick's, there's nothing, in relation to the opt-out versus opt-in issue, there is nothing in Merrick's which says that opt-out actions are always to be preferred to opt-in actions. Paragraph 13, Lord Briggs merely notes that collective proceedings may be brought on either basis, but doesn't say anything about there being a presumption or predisposition, which is UKTC's argument. It's true that at paragraph 92, UKTC rely upon this, Lord Sales and Leggett note that opt-out proceedings are, quote, a significant innovation which are designed to facilitate access to justice for those who lack the awareness, capability or resolve required to take the positive step of opting into legal proceedings. Now, my lords, one can see obviously what they had in mind was a very different case to the present case. And what we have here is the CAT taking the decision that the proposed class members here would not lack the awareness or capability to take the positive step of opting in. We've just seen that in paragraphs 217 to 223. So on the question of opt-out versus opt-in, with respect, Merrick's doesn't assist UKTC. Now, on aggregate damages, they do rely upon paragraph 57, and perhaps I can just show you paragraph 57. Merits, my lords, is behind tab 26.
Which volume is that?
My lord, if I have 4 volumes, and it's in volume 2. And this is really the high watermark of UKTC submissions on why the CAT erred as a matter of law. Paragraph 57, my lords, is page 1075 of the bundle. And Lord Briggs says, the pursuit of a multitude of individually assessed claims for damages, which is all that is possible in individual claims under the ordinary civil procedure, is both burdensome for the court and usually disproportionate for the parties. Individually assessed damages may also be pursued in collective proceedings, but the alternative, aggregate basis, radically dissolves those disadvantages, both for the court and for all the parties. In general, although there may be exceptions, defendants are only interested in the quantification of their overall, i.e. aggregate liability. For the claimants, the choice between individual or aggregate assessment will usually be a question of proportionality. And Mr. Thompson says, look, there is Lord Briggs saying aggregate damages are inherently better than non-aggregate damages. And the problem with that submission is twofold. One, Lord Briggs himself goes on, for example, at paragraph 61, to note that at the end of 61, it's not a condition that the claims are suitable for an award of aggregate damages. That is only one of many relevant factors in the suitability assessment. So even Lord Briggs there is clearly not saying aggregate damages are always preferable. It's just a factor that goes into the pot. But secondly, the reason that paragraph 57 doesn't assist UKTC is because in the present case, the RHA, it's true that they are claiming non-aggregate damages. They're not claiming aggregate damages, that's clear, but equally, they're not claiming damages on a basis which will require an assessment of every single claimant's position individually. And this is quite an important point. It's why the CAT described this argument by UKTC as being misconceived, because it's wrong to equate what the RHA are doing with an ordinary situation where in a group action, for example, a claimant is, or multiple claimants are seeking damages on an individual basis. And if I can just show you, perhaps show you parts of the judgment where they summarise what Dr. Davis is doing. But if I can have a go and then perhaps show you the references. But what Dr. Davis is doing, and one sees this in the reports, and I'll give you the references in a moment, but essentially, Dr. Davis's methodology consists of dividing all of the proposed class members into 6 subclasses. He says effectively there are broadly six categories, whether it's new trucks, used trucks, whether it's purchase or finance, and so on. And then within each of those categories or subclasses, he says he will control for different characteristics, because he accepts that within each of those 6 subclasses, there may be different transaction-specific factors. So, for example, the type of truck and the nature of the dealer and so on. But then he's going to arrive at an average per truck overcharge figure within each subclass. And it's the fact that he intends to adopt this averaging approach, which is the reason I say this is not an individually assessed damages claim. And if I just show you what the CAT says about this, first of all, in the main judgment at paragraph 127, page 274 of the bundle, you see there the 6 subclasses that Dr. Davis intends or proposed at the certification step. And you'll see the reference in the penultimate line there, the extent of average overcharge within each subclass. And then at 131 over the page, you'll see the reference to the bottom-up basis. So it's an estimation of the damage for each truck. And then at 135, you will see the quote from the oral evidence of Dr. Davis. The aim of the methodology is to get to individual damages, But then you'll see he goes on to say in the penultimate line in the quotation, there's a degree of averaging ultimately. And then at 182, again, the CAT explains Dr. Davis's methodology. They say the different regressions in his various analyses by different categories will result in average figures for trucks in each category. They will always be average figures, and then another reference to bottom up. And my lords, that's why when we then go back to the permission to appeal ruling, the next tab, at paragraph 34, that's the reason why the CAT refused permission and described this argument by UKTC in reliance upon paragraph 57 of Merrick's. They say that's misconceived, and the reason it's misconceived, the part of this paragraph I didn't take you to earlier, halfway down, they say we regard it as a complete mischaracterization of the approach of the RHA's expert to suggest that his method involves individuated damages corresponding to a multitude of individually brought claims. On the contrary, as Dr. Davis explained in substantial detail in his reports, he would develop methods for calculating on the way overcharge should be estimated on a common basis, and varying according to the different ways in which the trucks are required, and a common method for approaching damages under the Euro emissions. And then they say, in consequence, it would then be relatively straightforward to apply those determinations to basic data from each individual operator to arrive at its individual damages. So, my lords, we say the CAT was right to describe that as misconceived, because Dr. Davis is using this averaging approach. And perhaps I can just give you the references before your lordships rise. If you do want to see further explanation from
The crucial point is they formed a view as to the quality of evidence.
Exactly.
That's it.
Exactly. I mean, I'll just keep saying that in different ways. But this point is, as I said at the outset, insofar as anything it could be even conceivably described as an error of law. One can see that if the CAT had misapplied the Supreme Court's judgment in Merrick's, then your lordships may start to be interested in that as a possible error of law. This particular argument is misconceived for the reasons I've just explained. But the other points get even worse, and I'll try and deal with them quite quickly tomorrow morning. But the other points do not even look like errors of law, in my respectful submission. But if your lordships, can I just give you the references, just to, in case your lordships want to see what Dr. Davis himself described. Paragraph 32 of Davis 1 is Supplemental Bundle, Volume 1, tab 10, page 134. And I would also invite your lordships to look at paragraph 94A of his first report, and 210 and 215. And they really just expand on the point I've just been making. This is not a classic individually assessed damages claim. My lords, I see the time.
Yeah.
At maybe a convenient moment.
Very well. 10:30 tomorrow, I think.